We will not.
Indeed.
There is no point, no? If otherwise there is no substantial question of law, what's the big idea of issuing notice even for condemnation of delay?
It's not a will satisfy Lordship on
That
that
is
point.
why on merit.
On that.
Right. Second appeal number 191 of 2025 with ID number
10436.
14050 of 2025 seeking condonation of delay of 82 days in filing this appeal. Let this matter be posted on 20th of December. Please तारीख को रखें.
Not.
20th of December 2025 to enable the counsel for the appellant to satisfy this court on the point of involvement of any substantial question of law in this case. Appropriate order on the limitation, appropriate order for issuing notice on the limitation matter will be considered on the next day along with the medical. Post on 20.
Item 37, second appeal 193 of 2025.
Value for in condemnation of delay.
Same story. I will you one. Unless I am satisfied on substantial question, I will not.
I will file a supplementary if there is a substantial question of law which I want to argue. It's not there.
You can do it. You can do it in the meantime. I am posting it on
20.
Mr. Roy, actually, that is not the procedure of our court. Normally, the notices are mechanically issued on the point of initiation. But I think it's a futile exercise. There is no substantial question of law involved. That's a good idea for condoning the details. So, a few cases I have fixed on that way. And I think this course, if we adopt this course, it will expedite the disposal of the matters.
I agree.
How much is the delay?
104 days.
104 days in order. Okay. Essay number 193 of 2025 with ID number 14907 of 2025 seeking condemnation of delay of 105 days. Then I will take a call on limitation. Would this be better for litigation?
Yes, then
That would be better for
better,
litigation.
yes.
Actually, what I am finding here is that in the second appeal, when notices are issued, we are coming across instances where the plaintiff died 20 years back, that one of the pro forma defendant died
Yes.
15 years
Unfortunate
back.
part of civil litigation.
And the entire adjudication is stalled because of that. And in the meantime, those who are parties before the court, they also die. And ultimately, we find that there is no substantial question.
Unfortunate part of civil litigation. The procedure laid
So
down.
we can just think of the procedure, how to handle it.
Leadership may on 20th whatever may condemn the delay and dismiss the appeal on merits.
Yes, that's
Because you
right.
are dismissing the appeal on limitation.
That's right, I understand that. And delay of 20 days, 30 days, or maybe 90 days also for that matter, or 100 days also. I think it's not much for a civil litigation. We'll see.
For finance to item 3, second appeal 261 of 2017.
IA was allowed
No,
for additional substantial question of law?
it has not been allowed. Your Lordship had granted them time to file their
Response.
response to this,
Have they?
and they have filed. I did not get a copy in my file, but I have gone through it and I have read over the file.
Where are they? Who's for the respondent?
He was arguing the first time. Mr. Sahai's.
Let us see what is the
Yes.
proposed.
I'll just briefly state
Yes,
the fact of the case.
yes.
I am
What is the
the
core dispute?
yes. I am the original defendant. Concurrently, findings are against me. The original suit was decreed. My appeal has been dismissed. This is the main matter. Now,
What was the suit for?
the suit was for declaration of right title interest, and very interesting story has been pleaded in the plaint. That is where my whole question would be. Now, your Lordship would find that the suit property is only khata number 1. Khata number 1, 34 decimals of khata number 1. There were two properties. Schedule A was the property which the respondent plaintiff claims that the Jamindar had settled by way of a Sada Hukumnama. This was their claim. Now by this they say that plot number 1, area 73 decimals was settled, and this also involved
In favor of?
their predecessor in interest. The total area of this Sada Hukumnama oral settlement was 1.07 acres.
07 acres.
1.07 acres, which includes the suit property. Suit property is plot number 229, 34 decimals.
Plot number
229,
229,
34 decimals.
34 decimals. This is schedule B.
This is schedule. And it is their case because this was settled to them, and this suit property over which I am claiming my right, it falls within their settled land, and therefore this suit for declaration was filed.
Okay, just a minute. SC number 261 of 2017 with ID number 7959 of 2025. The learned counsel for the applicant has submitted that the interlocutory application has been filed for claiming additional substantial question of law, which are as follows. Para 4 se quote kar lenge. He has submitted that a response to the interlocutory application has already been filed by the respondents. However, counsel for the respondents is absent. While giving the background of the case, the learned counsel submits that the original defendant.
Yes. A little more fact is required.
I just please hold on. ये ना पीस मिल करने से ठीक रहता
नहीं
है, तो
ठीक
miss
है
हो
ठीक
जाता
है ठीक है
That is more convenient.
ये एक्चुअली क्या है ना, your lordship, I was actually confused how to place the matter. Strange story is there. Therefore, Allah.
Only single defendant.
Yes.
Original defendant is the appellant before this court. The suit was decreed and the appeal has been dismissed. The suit was filed for declaration of right, title and interest over Schedule B property.
Yes.
He submits that the suit property is in plot number 229, area 34 decimal, as described in Schedule B, and Schedule B is a part of Schedule A property. He further submits that, as per the specific case of the plaintiff, the Schedule A property was settled by way of Sada Hukumnama,
Oral settlement. They only say
by
oral.
way of oral settlement in favor of predecessor in interest of the plaintiffs, having total area 1.07 acres. Right?
Yes.
Yes, then.
Now your Lordship may allow me to place the plate. Now what they say, their whole story,
Respondent का नाम.
their whole story now starts in the plate with regard to Khata 2 properties, not Khata 1. Now they say that Khata number 2 property, area of approximately 1.39 acres. 1.39 acres of Khata number 2 was transferred to them by way of a registered deed of sale.
I couldn't get it. You have given me the plot number.
Yes.
Schedule A is in khata number?
Khata number 1.
Okay.
The entire
Schedule
dispute,
A के बारे में खाता number 1 लिखेंगे.
the entire dispute is with regard to
Yes, sir.
Khata number 1.
Yes, now you tell us, where is the dispute now?
Yes. The plaintiff now says that how their predecessor in interest acquired Khata number 2 property, and then I may be allowed to read, that would be better. Your Lordship may take up the plaint.
Do we find it? Okay. We are in the thing.
If your Lordship has plaint
Yes,
itself.
I have. Paragraph.
I'll start from 2. One only. That one Toki Mahto, son of late Tuli Mahto, was grandfather of the plaintiff. That Toki Mahto purchased 1.39 acres of Khata number 2 of village Mundaro, so and so, Hajaribagh, now Giridi, from Jagannath Layak, Chandramohan Layak, Udit Nayak, so and so, by virtue of a registered deed of sale, number so and so, dated 10/5/1944, registered in the office of Registrar Hajaribagh on annual rent of ₹3 including rent. That on the very date of purchase, the said Toki Mahto came in possession of the purchased land. Here I'll pause. Your Lordship may only take note of this fact. That he says that his predecessor in interest had purchased 1.39 acres of Khata number 2 and he came in possession on the date of purchase also. Now he says, by virtue of said sale deed, Toki Mahto purchased 56 decimals out of 1.14 acres of land of plot number 130, Khata number 2, along with other lands, but soon after the purchase it came in light that the vendors had only 10 decimals of land under plot number 130 in their possession to sell, so the purchaser Toki Mahto came in possession of only 10 decimals of plot number 130 of land instead of 56 decimals, as the vendors had earlier sold 46 decimals of plot number 130 to Raghuvir Mahto. Toki Mahto came in possession of 93 decimals of land out of 1.39 acres of purchase. Now what they say?
This 93.
Yes. Now what they say? This is your Lordship. They say that although they themselves make a very specifically by registered deed of sale, someone has sold the 1.39 acres to them, but because their vendor had already transferred 46 decimals prior to their execution of sale, therefore this was deducted from their own registered deed. And
Deducted.
this is why here my first.
No, they say that they came in possession of that. That does not mean that the area is deducted.
They say, no, this is their whole case.
No, that is.
I'll come to that.
Please don't read between the lines in the.
I'll not read. They did not come in possession.
They did not come in
But-
possession of the entire property because 46 decimal was already sold.
Yes, this is their case. Now I may be allowed to. I'm not reading between the lines. Now I may be allowed to read further. That the name of Toki Mato was mutated in the office of the then landlord with respect to 93 decimals. That means the deducted area.
No. The mutation was only in connection with 93 decimal. That does not mean that the sale deed was in relation to 93 decimal. There will be a difference.
Sale deed was with regard to 1.39 acres.
1.39 acres.
Yes.
But this mutation, whatever the receipt, right? The mutation was only in connection with 93 decimal because that was in their possession. Rest was not in their possession. How the entire property could have been mutated in their name? Mutation and title will go not always same.
No, not always same. But I may be allowed to read further what their case is not related to Khata number 2. Their
Let us-
whole case is
let us see
related to
further.
Khata number 2.
And the rent described in the sale deed was reduced. That's right.
Yes.
The rent was reduced, but the title has not been taken away from them.
So what is their case they are making out? That is
Let us see.
that the name of Tokimato was mutated in office of the then landlord of village with respect to 93 decimals of purchased land, and the rent described in sale deed was reduced according to the shortage of 46 decimals of land of plot number 130. The land under Khata number 1 of village so and so, Thana number so and so, village Bagodar, now district Giridih, was Bakas land of the Khewatdar, Dashrath Singh and others of Khewat number 3/2, and at the time of survey operation they were in possession thereof.
This is in connection with some other property.
Pardon?
This para 5 is in connection with some other property. It is not relatable to this property.
No, I stand corrected. Now they say that Khata number 1, now the story with regard to Khata number 2, whatever they purchased, this ended in para 4. Now Khata number 1 story starts that Khata number 1 was belonging to the landlord, and then para 6. That in or about the year 1945, Masoudi Singh was the landlord of the said village Mundaru, and he was in khas possession of the land under Khata number 1, including plot number 51 and 229. These are the two portions where Schedule A property. That the said Masoudi Singh settled 73 decimals of land of plot number 51 and 34 decimals of plot number 223 of Khata number 1, fully described in Schedule A of the plan below with Toki Mato in the year 1945 by oral settlement, and put him in khas possession thereof. The ex-landlord, in confirmation of the settlement, received rent from Toki Mato and granted rent receipt thereof. That the annual rent of the above settled land of 1.07 acres together with 93 decimals of land purchased by Toki Mato by virtue of sale deed dated 10/5/1944, total 2 acres was fixed ₹3 excluding cess by the landlord. That the land under plot number 51 and 229 was
So just a
transferred.
moment, how does they come to 1.07? 1.07, how do they come to 1?
It is total of
1.07 is the settled land
No.
by oral settlement, and 93 decimal was through the sale deed,
Okay.
which was
This is the settled
1.39.
land. Settled land. And
yes, para
93
7,
decimal is
para 7.
say.
Para 7 they have said.
Fair enough. Yes.
73 decimals of plot number 51 and 34 decimals of plot number 220.
That's it. 73 plus 34 would be
107.
107.
That is 1 acre, 0.7.
Okay. So settled land is 107 decimal and purchased land is 93.
93.
So
That Tokimato paid rent to the ex-landlord and then he died leaving behind so and so. And then para 12, that after the death of Tokimato, Token Yadav and Khemchand Yadav disrupted their name, their mess and also partitioned so and so. Last 2 lines here, 3 lines here, that in the partition land, Schedule B below is the part and parcel of Schedule A land was allotted to the share of Token Yadav. And then they say that we disrupted their possession and therefore they are filing the suit with regard to because we are claiming our right over Schedule B property and therefore they have been compelled to file the suit for declaration.
plot number 229, area 34 decimal, which is relatable to the settled land
Settled.
and not to the purchase.
No, this is this.
So what is your additional substantial question?
Pardon?
Additional substantial
Yes,
question.
yes. Now, Your Lordship, their whole case is that because the land was settled to us, now what the plaintiff has tried to make out a case that although the registered deed of sale is 1.39 and this story was pleaded by them only to prove their case with regard to Khata 1 property, that although I have purchased 1.39 acres, but because my vendor had already lost, he did not have title over 46 decimals of land and therefore I came only in possession of 93 decimals.
That's right.
So here was a registered.
No. They do not say that the vendor did not have the title. They say that the vendor did not have the possession.
Vendor has already transferred the land.
Okay, it was already transferred.
Yes.
Okay,
Hit by
sorry.
section 48
That's
IPS.
Your Lordship, here my substantial question of law is that in para 3 what they say that 1.39 acres was the total area which was involved in the sale deed, but because the vendor had transferred earlier sold 46 decimal to Raghuvir Mato, who is an outsider. And therefore, we only came in possession of obviously, Your Lordship, they are also saying that my vendor did not have.
Have the title, so I acquired title only to
Yes, only to. So, this particular pleading of theirs, which is against, so neither of them, they get a cancellation with regard to 46 decimal,
That's it.
and they also no sale deed with regard to Raghuvir Mato of 46 decimal was ever produced by them.
Okay.
So all these chain of title was required to have shown that as actually when there was a registered deed of sale with regard to
That will be
1.39,
assumed to be correct.
it has to be presumed. So
That's right.
how can a person in against a deed
See,
of
they have pleaded against themselves.
their own and
That's right.
yes.
They have pleaded against themselves and they said that the property in connection with only 46 decimal of land was available because, how much? 93 was available
90.
because 46 was already transferred.
Yes. So why they are making this story? Because to shift this to another portion, to Khata number 1 property. This is the whole reason.
No, what is the additional substantial?
Additional substantial question of law that once they say that there was a registered deed of sale where 1.39 acres was purchased by their predecessor in interest.
You see, under any circumstances, the purchased property, right, the purchased property, which is covered by the registered sale deed, is not relatable to plot number 229.
So it is not.
Apparently, it is on the face of the plate, it is not relatable.
Yes.
Then under such circumstances, what is the big idea of producing this particular sale deed of Raghupur Yadav for which you have framed a substantial?
Why I say it? Because Your Lordship, because now they say that they have not been able to prove that this 93 and
Okay, that
what was the
bifurcation is
area.
not available.
So what they are now trying to, they have proved and before the court below that because the landlord's records showed that khata number 1 and 2, the total rent was being collected was ₹3, and therefore this particular plot, my plot, was also involved in it. Only to show that
Does your plot fall in this 46 decimal of land?
no,
Then
no, it does
nobody is
not.
bothered about it.
It does not fall.
Nobody is bothered about it.
So without this, they won't be able to prove their
You
own
forget
case.
it. We'll see. Because there is already a substantial question of law framed. Then why do we need this? For this, in order to argue this, no adverse inference. You see, it can always be decided along with the main substantial question of law.
Whatever,
has been framed.
as your lordship, that can
You see,
always be done.
There can be number of legs of a substantial question of law, different contours of a substantial question of law. If a particular document is not produced, then what is the reason for non-production? Whether any adverse inference is to be drawn or not? This will, I think, fall.
Portions of,
contours.
I do agree to that.
Then under such circumstances, what is this? कुछ नहीं है आपका ये सब. ये आप थोड़ा सा आपका
नहीं
प्रोफेशनल
नहीं, हमको चूंकि बनाना तो है.
नहीं, कभी
Now-
ऐसा भी होता है.
now,
Just a minute.
what the
ऐसा
trial
भी
court-
कभी होता है.
हाँ.
That when you are placing a case before the court, things become all the more clear.
हाँ.
Apart from just reading it in the document. कभी चेंबर में पढ़ के लगता है कि ये है, लेकिन जब आप उसको पूरा threadbare place करते हो, then you realize that आप भी बताइए on the face of the plate, how the evidence of this particular deed of Raghubir Yadav will have a bearing in the matter.
Because the courts have both the courts
What
rely
is the
on
main, what is the
and
substantial question of law which has been framed? You tell us. हम भी कभी घर से पढ़ के आते हैं तो कोर्ट में आप लोग की बात सुन के कुछ अपना नया माइंड भी फ्रेम होता है. ऐसा नहीं है. कोर्ट में आर्गुमेंट नई चीजें सामने आती हैं. तो
ठीक.
we have to be absolutely open. क्या है बताइए आपका substantial
जो already framed was 13/11/2019.
Yes, I am there. Pardon?
Whether the appellate court has below judgment is perverse for considering exhibit 4 and 4/1, which is registered 2 in the name of Toki Yadav, who is ancestor of the plaintiff, and at the same time not considering exhibit A filed by the defendant, which is certified copy of register 2 showing defendant Balu Yadav, who is the appellant in second appeal. Thus, in view of the matter, the judgment of appellate court is perverse.
Right?
But only mutation reports that would not
That
be.
you will have you. That you will have you. Whether on the basis of mutation record anything can be decided. And to what extent the parties have been able to prove their title with respect to the suit property.
Now, my proposed substantial question of law, if your lordship would kindly see. There are 3.
Okay.
First one was obviously non-production of
That's absolutely.
Raghubir Yadav's sale deed. Second was whether the judgment and decree passed by the trial court and first appellate court is against the plaintiff's source of title, that is sale deed dated 10/5/1944, and therefore the same is perverse. And the third one is whether the learned trial court has decreed the plaintiff's suit against the provisions of section 19. That means against a registered instrument, no oral evidence can be laid. So, but all these relate to the first document, first sale deed of the year 1940. All these things.
You see, this particular document, the registered sale deed of 10/5/44, is an admitted document on record. Is it disputed?
The registered
So
deed?
far, yes.
No.
There is no dispute.
Because I am not being affected by that
And
document.
you are claiming property which is covered by the registered deed, or you are claiming
No,
property
no.
which is covered by the settlement?
Settlement.
So you should not be bothered about this registered
I am
deed
not
at all.
bothered unless and until once what they are trying to do, they are trying to make fit this in calculation because there
They
was
can't, खाता number one cannot fit into calculation in खाता number two.
वो उसका उसी का तो एविडेंस में आएगा, इसी के लिए तो हम
भाई
बोल रहे हैं।
plain ही यही है ना, खाता number one. There are two properties. One is in खाता number one, other is in
एकदम,
खाता number
एकदम,
two. How do they
एकदम।
merge?
मर्ज उनका जो रजिस्टर जो जमाबंदी जो ये है लैंडलॉर्ड के यहाँ, उसमें ये दिखा रहे हैं कि टोटल एरिया 2 एकड़ है, बस उसी से पूरा केस है।
खाता नंबर वन और खाता नंबर टू आर टू
नहीं, अब हम बता रहे हैं टोटल 2 एकड़ उनको फिट करना है, तो एक तरफ तो 73 दिखा रहे हैं, और अगर उसमें ये दे वुड टेक 1.46 acres, then it exceeds and that would not match their full story. That was the reason of
Have they been able to show from the zamindari receipt or whatever that it was relatable both to खाता number one and खाता number two?
खाता नंबर
क्या आपके zamindari rent receipt में खाता one and खाता two दोनों included हैं?
It is exhibited.
What is the source of the title? There are two sources of title. One is the registered deed, other is the settlement.
Oral settlement.
Whatever.
Because they lay claim on a written settlement. That is a sada hukum, which is not followed by zamindari rent receipt. And the land is a
No, they are
bakas.
the defendants. We forget about it.
The land is
You
a
are the
bakas.
plaintiff.
But what I'm saying is because the land is a bakas land, and if it is reduced in writing, so under sections 117 of the TP Act, it has to be necessarily registered, and that view has been taken
You
care of.
forget about their case. They
My
have
source-
lost in both the courts now. You have two sources. One is the registered sale deed,
My
right? And the other is hukum.
hukum.
You produce the registered sale deed.
My
It is your document,
my
right? You have not produced any document to show that any portion of that registered sale deed was already sold to somebody.
no,
That is not there.
no.
So your sale deed will survive as it is,
Yes,
right?
yes.
Now you say that you are claiming the property. What is the total claim of your property?
2 acres, ma'am.
2 acres.
93 decimals through registered sale deed
Yes.
and 107
Why
decimals
93 decimals?
because they have laid the claim on 93 decimals.
But why?
The reason being that 46 decimals of
Where
land.
is the evidence?
There is no evidence.
You
There is
cannot
only
dispute your own title
My
deed.
lord, that is the case that has been made by the plaintiff. is
But
that
you cannot dispute your own title deed unless you produce the sale deed which was pre your sale deed.
Yes, that was pre my sale deed.
From where do we say this?
There is no document, madam.
There is no
Why?
document.
Why there is the plaintiff have laid the claim only to the scope of 2 acres is because the rent assessment has been reduced to 2 acres. First, in respect of the oral settlement, which is to the extent of 1 acre and 7 decimals, and along with that, जो इन्होंने
तो 2
रजिस्टर
एकड़ पूरा करने के लिए दूसरे के घर में घुस जाएंगे.
नहीं मेरा रजिस्टर्ड सेल डीड से है दूसरा.
आपका रजिस्टर्ड एक सेकंड. आपका 1 point your mutation is in with respect to खाता number 1 and 2 both
Yes.
or not?
दोनों का कंबाइंड एक असेसमेंट मेरा हुआ.
खाता number 1 2 दोनों लिखा है कि नहीं लिखा है?
लिखा
लिखा है ना?
हाँ.
ठीक है. तो आपका खाता नंबर 2 से that is through the हुकुमनामा नहीं oral settlement.
ओरल सेल.
You have 1.07 and you are also claiming title by virtue of a registered sale deed. Right? आपका registered sale deed का title कितना है? कितना है इसका total area?
हमारा रजिस्टर्ड सेल डीड का 1.39 acres.
1.39.
39 acres.
और आपके अनुसार आपके पास कितना था? Sir, 93 was in your possession according to. So you want this 93 to be included to make it 2 acres, right? You have given up your claim so far as the remaining
46 decimals.
46 decimals is concerned.
And there is no rent fixation to that.
That's right. So you are only claiming 2 acres.
उतना ही हम मेरा
What is their claim? उनका claim क्या है?
मेरा है.
हाँ, आपका किस में है?
हम
आपका registered sale deed के अंदर है कि उसके बाहर?
नहीं बाहर है. इनका जो कैलकुलेशन एक बार वो जरूरी है, क्योंकि सारा रेंट रिसीट ये ला रहे हैं 2 एकड़ का, जितना सब कुछ।
हाँ
खाता नंबर 1 में 1.07 है,
हाँ
खाता नंबर 2 में
खाता नंबर 2 में होगा ना, खाता नंबर 1
1 में 1.07, खाता नंबर 2 में 1.39 है, टोटल हो जाता है 2.46। और सूट प्रॉपर्टी जो 34 डिसमिल सिर्फ है, तो 46 एक्स्ट्रा जो हो जा रहा है वही 46 दे। नाउ दिस इज द रीजन दैट दिस होल स्टोरी दैट my vendor had already transferred to a third party 46 decimal he was not having, and therefore this is the whole reason. So the trial court and the appellate court, they'll at least go into this question, because the registered deed is of 1.39. The plaintiff could not have gone against his own case. He is purchasing the property by way of a registered
नहीं, हमको
document.
ये नहीं समझ आ रहा
हाँ।
प्लेंटिफ को क्या फायदा है ये
प्लेंटिफ
बताने
को यही फायदा है,
क्या फायदा है?
यही फायदा हम बता रहे हैं।
क्या फायदा?
क्यों 46 छोड़ रहे हैं ये समझना जरूरी है।
हाँ
अगर 46 नहीं छोड़ेंगे तो इनका सिर्फ रेंट जितना जमींदार के यहाँ का प्रोड्यूस किए और रजिस्टर 2 में जो एंट्री
बस उतना ही
है
मिलेगा।
सिर्फ 2 एकड़ है, सिर्फ 2 एकड़ है, 46 डेसिमल एक्स्ट्रा हो जा रहा है। अगर इनका डीड को कैलकुलेट करेंगे तो 2.46 एकड़ हो जा रहा है, और जबकि इनका सारा डॉक्यूमेंट है सिर्फ 2 एकड़ का। तो
सारा डॉक्यूमेंट जब इनके पास 2 एकड़
हाँ, तो मेरा ही प्रॉपर्टी उस 34 डिसमिल उसमें कैसे ये प्रूफ करेंगे ना। मेरा जो 34 जो आ रहा है, बिकॉज खाता नंबर 2 your lordship, खाता नंबर 1 में I had earlier pointed out there is another plot also. Only one plot is in dispute.
Yes.
Plot number 229,
That's right.
and which I am claiming. So another portion is plot number. Plaintiff is filing a suit, so plaintiff has to make out a clear case that this is the exact portion over which I am entitled to. Second is plot number 51, area 73 decimal. But this is not in dispute. Disputed portion, and this was related to kata number 1. So this was the reason I say that they make out a case that my vendor did not have title over his subsisting right to transfer on the date when the property was transferred to me, and therefore they by themselves
Was the
declared
title deed under challenge?
their title deed.
Your title.
No, mine is sada. My case is weak. I'll not say that, Your Lordship, because the trial court, although the appellate court has only gone into the question of my title, and instead of going into my against me are that the courts below have found that on the date of settlement my age was only 10 years, and other this was the main reason, that because I was a minor I could not have, the land could not have been settled.
So therefore, their title can be declared only in connection with 2 acres of land is declared. Nothing more. Not even an inch of land more.
Absolutely, I don't have any objection. I could not have.
So therefore,
But how because they are including this plot number 229, and both courts below do not even go into that question, then how can a decree be passed against me? My plot is 229. No rent receipt, no jamabandi, nothing is there with regard to this plot number.
plot number 229 is a part of Schedule A property.
Schedule A settled land,
Settled.
which they
It's a
claim.
part of the settled land.
Yes.
Schedule A property.
Yes, they claim. Now, my contention would be,
एक सेकंड थोड़ा सा
ठीक है एकदम।
as per the plaint. Teku Mehto was the grandfather of the plaintiff, who had purchased 1.39 acres of land of Khata number 2 by way of registered sale deed number 2173 dated 10/5/1944. However, it is further case of the plaintiff that they came in possession of the purchased property soon after purchase. At the same time, it has been asserted that it came to light that the vendor had only 10 decimal of land in plot number 130 instead of 56 decimal. Although 56 decimal of plot number 130 was part of the registered sale deed. And it has also been asserted that the vendor of the father of the plaintiff had earlier sold 46 decimal of plot number 130 to one Raghuveer Mehto, and consequently, out of 1.39 acres of land, the plaintiff came in possession of only 93 decimal of land, although the registered sale deed was for 1.39 acres. It has been further asserted that consequently the mutation in the office of the landlord pursuant to the registered sale deed was confined only to 93 decimal. With respect to Khata number 1, the case of the plaintiff is that they acquired the same by virtue of oral settlement from the landlord, and it included property in plot number 51 and 229. The area of the settled land was 1.07 acres within bracket 73 decimal in plot number 51 and 34 decimal in plot number 229. Bracket close. The settled land is described in Schedule A of the plaint. It has been asserted that the annual rent of the aforesaid settled land within bracket 1.07 acres and purchased land within bracket 93 decimal of land out of purchased area of 1.39 acres, bracket close. And thus total area of 2 acres was fixed at rupees 3 as rent of 2 acres, na?
Two.
It was the Schedule B property consisted of 34 decimal of plot number 229, which, as per the plaint, formed a part of settled land,
Khata number 1.
falling in khata number 1. The case of the plaintiff further is that Teko Mehto died leaving behind his sons, two sons, namely Tokna Yadav and Khemchand Yadav, who came in possession of Schedule A property. However, after the death of Teko Mehto, Tokan Yadav and Kheman Yadav, they disrupted their mess and also partitioned the suit land in Schedule A and allotted their respective shares. In the partition, the land in Schedule B was allotted to the share of Tokan Yadav, who amalgamated some area of plot number 229 with his Rayati land under plot number 225, which was adjacent to plot number 229. After vesting of Zamindari, the revenue register 2 of the village was prepared in the name of Teki Mehto with respect to only 2 acres of land.
Yes.
And after vesting Zamindari, the rent of Schedule B along with other land. The plaintiff claimed that the rent with respect to Schedule B and other land was being regularly paid to the state of Bihar. Semicolon. Tokan Yadav died in the year 1988, leaving behind his 3 sons, and they came in possession of the land including Schedule B property. It was asserted that the sons of Tokan Yadav constituted a joint family property in which Dhalo Yadav, being the elder brother, was the katta of the family. The plaintiffs had also erected a brick compound over the portion of Schedule B property and had remained in continuous cultivating possession over Schedule B property for 12 years and had also acquired the title by adverse possession. The cause of action arose when on 26/2000, the defendant Balu Yadav came upon Schedule B land and sought to dispossess the plaintiff from Schedule B property and started denying the title of the plaintiff. That's all. The plaintiff prayed for adjudication of subsisting Rayati right and title over the suit land and sought a declaration to that effect, and also sought confirmation of possession over the suit property, and if found dispossessed from the suit property during pendency of the case, khas possession be restored to them. The plaintiff also sought permanent injunction. The defendants had one written statement. The defendants had only defendant.
Only different.
The only defendant had filed a written statement and
I was claiming only 32 decimals of
And
plot number.
claimed only, how much?
32 decimals of plot number
32
229.
decimal of plot number 229 by stating that the ex-landlord as early as in 1941 made settlement of 0.40 acres of land in plot number 51 with definite boundary. And claimed that the father of the defendant, Veglal Neto, came in actual physical possession. And as such, the ex-landlord in the year 1941, out of total India 1.50 acres, made settlement of 0.40 acres of land in plot number 51 within a definite boundary and with detailed and described in identity, and similarly made settlement of 0.32 acres of land out of 0.34 acres in plot number 229 in the name of the defendant by way of Sada Hukumnama in the year 1941 by ex-landlord namely Masudi Singh. Thus, the defendant claimed to have acquired 0.72 acres of land of Khata number 1 of village Munro, Thana number 82, Thana Bagoda. 72, ये 72 का क्या calculation है? 34 and
32 and
32 and 51.
50.
51 तो भी तो नहीं होगा.
No, 32 and 40.
32 and 40.
40.
2, 7. It is लिखेगा, इसको मैं edit करने वाला हूँ. The defendant claimed for 0.40 acres of land in plot number 51 and 0.34 acres of land in plot number 229 by virtue of Sada settlement.
But the suit property is only
From the same landlord,
same.
from the ex-landlord namely Masudi Singh, however, a total being 0.72 acres. However, the suit property is only 0.34 acres in plot number 229. However, the defendant claimed only 0.32 acres in plot number 229. तो बाकी दो डिस्मिल में तो आपका कोई डिस्प्यूट नहीं.
नहीं उसमें कोई उसमें का ये भी नहीं. Your Lordship, I only wanted to bring to your Lordship's kind attention only one paragraph of the appellate court here. That your Lordship ने कही.
एक सेकंड थोड़ा सा इसको और कम.
अच्छा ठीक.
The defendant also claimed that the father of the defendant got the land measured with the help of Amin, and accordingly further the report of Amin was prepared on 14/4/1942, and the answering defendant had become the recorded tenant of the ex-landlord and paid rent after vesting, and consequently became the recorded tenant of the state and has been paying rent regularly, and which has also been duly recorded in Register 2 of the state. It was also asserted that the defendant came in actual physical possession of the entire 0.72 acres, including 0.32 acres which formed a part of the Schedule B property. It was also asserted that 0.02 acres of land in plot number 229 was in actual physical possession of one Lato Yadav, a co-sharer of the defendant. Thus, the defendant disputed the title and possession of the plaintiff with respect to 32 decimal of land of plot number 229 out of 34 decimal of land in plot number 229 of schedule B of the plaintiff. अब बताइए आपका एडिशनल सब्सटेंशियल क्वेश्चन ऑफ नॉमिनी क्या है?
हम एक लाइन खाली देखा दे रहे हैं अपीलेट कोर्ट का पेज 8 फर्स्ट एक पैराग्राफ देख लिया जाए दैट इज द डिस्कशन
It is
with regard to how the plaintiff has acquired title. Rest all are against me that I do how my Sada Upurnama is back. Page 8, first paragraph. Because you Lordship, the appellate court in page 6 frames 3 points for determination.
page,
Page 6.
okay, page 6.
It frames 3 points for determination.
Yes, and then
Yes. And obviously it is whether the trial court was justified in holding that the plaintiff has got title over the suit land, whether the trial court was justified in holding that plot number 51 area 0.73 acres and plot number 229 area 0.34 acres was settled with Toki Mato orally in 1945, and then point number 1 and 2 the appellate court discusses together, and in page 7 it is only section 117 is quoted, and then relevant one paragraph in page 8 here, first paragraph, top. I have perused the documentary evidence filed by the plaintiff and find that the plaintiffs have brought exhibits 3B to 3D, Jamindari rent receipts of an area of 2 acres. The case of the plaintiff was that their father took the settlement under Khata number 1 of an area measuring 1.07 acres and got sale deed of an area measuring 93 acres only, 0.93 acres only. Whereas your Lordship, the sale deed is actually 1.39. On its own, the appellate court is assuming 0.93 acres in Khata number 2, and rent was accordingly realized.
this actual figure should be
1.39.
just a moment. Khata number 1 is
1 is correct. Khata number 1,
and saying
1.07.
measuring this is 1.39, right?
Yes. So it is accepting the case of the plaintiff that actually the sale deed was 1.39, but if without it had, their vendor did not have title over 46 decimal, and therefore it is deducting this area,
You just read for it.
and no finding prior to that.
Plaintiff has
Absolutely.
further filed
Yes. Acres in Khata number 2, and rent was accordingly realized by the landlord of total area of 2 acres. Plaintiffs have further filed exhibit 3 to 3A, 3C, so and so, 3 all government Malgujari receipts issued in favor of Toki Yadav that relates to the land under Khata number 1 and 2 for an area of 2 acres. Certified copy of registered 2 that are exhibit 4 and 4/1 have also been filed by plaintiff, that is also running in the name of Toki. And then no discussion whatsoever subsequently. It only now says in para 14 onwards that I do not have that.
सेल डीड में एरिया कितना मेंशन है?
किसमें?
सेल डीड में एरिया कितना?
1.39 acres.
So you want to say that this finding is perverse, that the purchase
Absolutely
was only to
perverse.
the extent
But
of.
I must say, concede that I was having difficulty in how to formulate this, because this was actually a finding which was against, and it was perverse. Because
Yes, what do you say? This finding is correct,
Manu-
and what is the basis of this finding?
In my humble submission, the third line, what sir was arguing, the case of the plaintiff was that their father took the settlement under Khata number 1 of an area measuring 1.07 acres and got the sale deed of an area measuring 0.93 acres in Khata number 2. Now, while 0.93 is indicated here, my lord would find at page 2 of the Learned Appellate Court's judgment, the entire history is written.
That's we have
The
seen
case of the
plaintiff
plaintiff,
and
the case of the
witness.
plaintiff, the case of the
We
plaintiff.
have seen the plaintiff and the witness.
Then it is referring to that part. It is not a finding, it's the case of the plaintiff.
Okay. So what is the finding? Replace the finding because we are on additional substantial. This particular, if it is just a case of the, this is the finding. I have perused the documentary evidence. What else? The finding starts in this manner only. See, it starts by saying that I have perused the documentary evidence filed by the plaintiff.
And the case of the plaintiff was that. In continuation, the case of the plaintiff.
Achha, so it is the case of the
It is the case of the plaintiff.
Okay, what is the finding of the learned first appellate court? According to you? The first appellate court has taken sale deed for 93 decimal, or
Yes.
they have taken it for 1.39 decimal?
No, 93 decimal. In
If they
view
have
of the
taken it for 93
93
decimal,
decimal,
then
because
that, what is the evidence with respect to taking the property only for 93 decimal and not for 1.39?
these zamindari rent receipts are for.
Zamindari rent receipt will not decide your title.
Absolutely correct, my lord. But what I am trying to indicate is that the plaintiff has not made a claim over the entire 1.39 acres of land. He has said,
he has
fine.
given a reason for not giving,
Yes,
for not making a claim.
yes, he says.
And therefore what he did, what he does it, what would exactly happen? If 1.39 is taken from khata number 2,
Two.
right? 2 minus 1.39 is how much?
1.39 minus
2 minus 1.39 is only 0.61,
that is 61 decimal.
right?
61 decimal.
61 decimal,
61 decimal.
right? So after the sale deed, registered sale deed, your claim would be only to the extent of 61 decimal
Decimals.
in khata number 2.
Two. Yes.
And what you have done? You have reduced your registered sale deed area to 93 and you have increased the area in khata number 2 in the settlement area.
Yes.
So therefore this finding, they are correlated to each other. You have to sum up to 2 acres.
2 acres.
Right? Now the point is which proportion is covered by sale deed and which proportion is covered by hukumnama is something which is material in this case. Isn't it? So when your sale deed, when your entire sale deed is 1.39 acres and you are not able to prove it by evidence that that some portion of it was already sold, then you cannot disown 1.39 acres. How will you disown 1.39 acres? And you are claiming only 2 acres. It is not your case that 1.39 acres plus settlement. That is not your case.
1.39 acres minus 46 plus settlement.
Yes.
That is my case.
That is your case. When you say minus 46, you have to substantiate minus 46 also. Otherwise, the sale deed is staring at you. Isn't it?
Yes.
So there is something, this finding, this is, you see, the case of the plaintiff was this, apart from that, here the finding of the learned court is only in connection with 93 acres of land in connection with the registered sale deed, although the registered sale deed was for 1.39 acres. And this is what you claimed.
And apart from this, there is absolutely no finding. No finding in the entire judgment.
So what I propose is, you see, this is something which is very intricate. Unless you actually go through the records, you cannot really frame an additional substantial question. The learned counsel for the applicant has submitted that the specific case of the plaintiff was has submitted that it is not in dispute that the registered sale deed of the year 1944 in favor of father of the plaintiff, right? Father of the plaintiff was for
Grandfather.
Grandfather of the plaintiff was for 1.39 acres. But the learned first appellate court has confined the sale deed only to 0.93 acres. And has included the area of khata number 1 to make up total area of 2 acres as claimed by the plaintiff. He has submitted that in absence of any registered sale deed in favor of Raghunath Yadav as claimed by the plaintiff in their plaint itself, stating that 46 decimal of land was transferred in his name. The area covered by the registered sale deed of 1944 could not have been reduced and confined only to 93 acres. He submits that the first appellate court has committed perversity while recording such a claim.
And the same is also against section 92 of Evidence Act, which says that when a document is registered, no evidence.
And he has submitted that the registered document has a presumption of correctness.
And my last submission would be that both the courts have not made this calculation
The learned counsel has submitted उतना
अच्छा
आपको
ठीक है ठीक है ठीक है नहीं वो नहीं
जब
मतलब
तक फ्रेम नहीं करेंगे तब तक नहीं
ठीक ठीक
The learned counsel for the respondents has opposed the prayer for framing additional substantial question of law. However, during the course of argument, it is not in dispute that the registered sale fee of the year 1944 in favor of the grandfather of the plaintiff was for 1.39 acres. And the plaintiff had claimed property of only 2 acres, which partly fell under, which was partly covered by the registered sale deed of the year 1944 and partly covered by oral settlement, falling in khata number 2 and khata number 1 respectively. After hearing the learned counsel for the parties on the point of additional substantial question of law, this court is of the considered view that कहाँ है आपका आइए
1 and 2 yellow chip both 7959
this court is of the considered view that following substantial question of law also arise for consideration in this case, which is formulated as under. Whether the learned first court by recording that the claim of plaintiff with respect to the claim of plaintiff in connection with registered sale deed was only to the extent of 0.93 acres in khata number 2. Has committed a perversity, particularly in absence of production of sale deed to the extent of 46 decimal of land as claimed in the claimed इतना ही होता है पर्पसिटी बोलने से ही तो हो जाएगा
अच्छा ठीक है
that will cover
एकदम
I think that should be sufficient अब आपको कब बहस करना है ये बताइए आपसे
हम
पूछ
तो
रहे हैं
ऑलरेडी
ये तो
पढ़
रेडी
चुके
है
हैं हम तो पढ़ चुके हैं
आपको कब बहस करना है
Maybe Friday.
Do you want time to argue
After the vacation will be the best for me. Because I have to
after
go.
vacation हम तो पूरा ही सुन लिए It is almost I have heard you for around धीरे धीरे सुनते हैं समझ कर ऐसे सब्सटैंशियल क्वेश्चन ऑफ लॉ तो हम बनाते ही नहीं बताइए कब करेंगे Can we start our hearing today? You can continue on the next day. That is one thing. It is absolutely open.
Madam,
I
we
would
will
like.
stick to it. No issues, Madam. Actually, as a matter of fact, I have not gone through the entire records. That is the fact.
क्योंकि एक नया एंगल है
हाँ, ये हमको पूरा records एक बार देखना
आपको
है
देखना होगा जरूर देखना
कि जो reduction हुआ है
हाँ।
वो
कितना
किस-
एक से हटा के कितना दूसरे में घुस
कितना
रहा है
में
ये
घुस
देखने की जरूरत है
समझ गए हम इशू हम समझ गए
ठीक है ये तो, देखिए एक और इसका एंगल है आप बोल सकते हैं कि ठीक है मेरा से 18 से तो हम इतना ही क्लेम कर रहे थे लेकिन बाकी का जो मेरा एरिया है वो इससे रिलेटेड And you can always say, we do not know, क्योंकि वो जो आपका जो एरिया 46 आप जो डिडक्ट कर रहे हैं वो कौन सा एरिया है उसका क्या बाउंड्री है वो भी नहीं पता एंड देन हुकुमनामा से जो क्वेश्चन आप क्लेम कर रहे हैं उसका भी बाउंड्री डिटेल्स नहीं पता ठीक है तो इट रिक्वायर्स आई थिंक वी हैव टू गो थ्रू द रिकॉर्ड्स अच्छे से थोड़ा मेट्रिकुलसली देखना पड़ेगा
So, I'm ready because I'm ready. I'm already gone through.
थोड़ा सा
तो नहीं
नोट्स
हो
भी
पाएगा।
बनाएंगे प्लीज प्रिपेयर द नोट्स आल्सो देखिए इतना देर सुने हैं लेकिन सारा कुछ लिखा ही नहीं
नहीं ठीक है
जो
but
जो
you
बोले हैं ना-
one thing I must confess while deciding the appeal what would happen that primarily these calculations would only come into play that whether the courts would have gone into all these were required or not or could have gone into or not if they have not gone into then the second option would have to be either setting aside or remand
रिमाइंड
setting aside or remand because
बस एक बात बताइए
हाँ।
इन अ केस वेयर देयर इज अ सेटलमेंट ऑफ 2 acres राइट एंड द plaintiff is claiming only 1 और उसका कोई बाउंड्री भी नहीं दे रही तो
हाँ।
उसका क्या सॉल्यूशन
नहीं ये नहीं है वो
मतलब कहाँ से पता करेंगे कौन सा पोर्शन का 1 acre
अगर एक चीज है अगर if the entire plot itself is let us assume 50 decimal and entire plot is being settled then the matter
तब तो
would
कोई
be-
दिक्कत नहीं आप ही जरा सोचिए इस चीज को है ना if only a if
Portion-
settlement is 2 acres and the plaintiff is only claiming a part of it so boundary becomes very
वेरी
important
वेरी
right आपका शेड्यूल में कुछ बाउंड्री है
है
And-
बहुत मुश्किल है ऐसा
and-
it's a peculiar case that the
नहीं।
plaintiff is disputing
नहीं,
his own
अभी
title
प्रॉब्लम ये है कि both courts have not gone into all these questions whatever your lordship is has
इतना
put up
टाइम नहीं
before
दिया होगा ना
अब यही अब देख लिया जाए पूरा पढ़ लेंगे पूरा हम पढ़ देंगे एक एक ये ट्रायल कोर्ट और एपलेट कोर्ट दोनों का
देखते हैं we just can't okay
पेज 9 ऑफ द प्लेट मलॉट उसमें बाउंड्री है
है
शेड्यूल बी सूट लैंड नॉर्थ रास्ता साउथ लैंड एंड अदर्स
boundary is there then oral evidence begins
ईस्ट बाउंड्री इज
अब तो सही में छुट्टी के बारे में
जो हम कभी ये इंसिस्ट नहीं कर सकते कि अनलेस बहुत अर्जेंट हो हम
नहीं कर पाएंगे हम
हाँ
कंप्लीट ही नहीं कर पाएंगे तो कर
नहीं एकदम आई कैन नॉट इंसिस्ट ऑन अ डेट एक ही में कभी कभी
रिटन स्टेटमेंट का जितना पानी है ना वो लिख देना कम से कम मेमोरी में जिसके पास भी जाएगा तो रहना तो चाहिए ना कि कुछ तो काम किया हुआ बेसिक ठीक है The matter is now adjourned since an additional substantial question of law has been framed. The matter is adjourned and is directed to be posted on 7th of January for final discussion. I yield this motion.
ठीक
Item 4, first appeal 136 of 2024.
Who is for the appellant? Yes.
I am appearing on behalf of the estate.
तो कुछ सुने तो लग रहा हमको। कहाँ है मिस्टर विशाल कुमार? Are you on cabinet?
No, estate.
State. आईए का रिप्लाई फाइल किया
मैं अभी नहीं।
एडिशनल एविडेंस सेकेंड अपील में या फर्स्ट अपील क्या है ये एडिशनल एविडेंस बताइए क्या है एडिशनल एविडेंस यस व्हाट इज द एडिशनल एविडेंस Nobody appears on behalf of the appellant and the private respondent. Are you there? Private respondent. जिसकी तरफ से respond now.
3 to 7.
Counsel for the appellant is absent. Now appearance. Pose his face. April 26.
Item 6, first appeal 70 of 2025.
For the respondent.
Yes. So the appellants had circulated an email that they wanted to manufacture.
Who is for the appellant?
The office of Mr. Prashant.
Have you commenced hearing in this case?
There's also an application for order 41/27 to which they had to file a reply which has not been filed.
Have you filed it?
We had filed an application on the
You have filed an application.
but
They are not filed any reply. Were they given any opportunity to file?
yes, I think the last order.
FA number 70 of 2025. Counsel for the appellant is absent. Learned counsel for the respondents has submitted that in spite of having given an opportunity to adduce additional evidence, to file reply to order number 11891 of 2025 filed by the respondents, no reply has been filed by the appellant so far. He has also indicated that An advance notice seeking adjournment has been circulated in this case. ऐसा तो कोई notice नहीं आया हमारे पास.
I had received an email message. It was circulated
Not
by
given to us.
Mr. Parth Jalal.
Not sent to us. ये last sentence बताओ.
It has been sent to court number 20.
Sorry.
It has been sent to court number 20.
कोर्ट का नंबर ही नहीं पता. The learned counsel for the respondents has submitted that an advance notice seeking adjournment has been circulated in this case, but it appears that it has been sent to court number 20 instead of court number 11. I would in order to give one more chance to the learned counsel, to the appellant. Post this case on 20th April 26. If reply to the initial evidence is not filed by tenth of April, no further opportunity.
Nelson case item 31, second appeal 154 of 2024 along with item 32.
Second case, my lord, second appeal 153/2020/18, my lord. This is an interim order, my lord. That is,
We have filed an interlocutory application today in this case, 153 of 2018.
This is 153.
Yes,
Should I take a 153 first?
150. Because 154 I am not the counsel, 153 is other counsel.
But both are related cases, huh?
Both are related in the sense that,
We have tagged it.
yes, it has been tagged by the other. 153 is concerned, because this is mentioned, I don't know whether the learned counsel is appearing in 154 he has been informed or not.
no, he has been informed.
So far as Nikhil
Nikhil Ranjan has been informed.
Nikhil?
He has told him come. Nikhil Ranjan.
There is.
Come.
In 153 we have filed an interlocutory application.
We'll come to that. 154 is perhaps not ready. Yes, why is it not ready?
Your Lordship, in this.
You are for whom? Respondent
I am for the applicant. In
or the
154.
appellant?
Yes.
No. In 154. You
In
are the
154, I am
appellant.
the applicant.
Okay. Alright. So is this case ready?
No, Your Lordship, perhaps some notices which was sent has not been served. It has returned unserved on some of the respondents because notices were filed upon all the respondents.
ये USP क्या होता है? No any USP? क्या लिखते हैं USP? क्या मतलब है इसका? What is the meaning of USP? Undelivered speed post. ऐसा ये तो वो WhatsApp वाला लैंग्वेज हो गया. हाँ? WhatsApp में लोग ऐसे ये सोचते रहे ये क्या लिखे. मैसेजिंग का लैंग्वेज notice was issued under by what process?
By both processes, Your Lordship, under on all the respondents, speed post as well as in view of the last orders.
Respondent number 9 is dead. You have not seen the office note.
For respondent number 9, I am aware because in the last office note itself it came. I am trying to find out the substituted legal heirs. That is why I couldn't file substitution petition. The previous office note itself said that he is dead. That is there in the order.
This report has not, of ordinary process has not been received. देखिए, as per office note, the notice has remained unserved. The speaker's notice has remained unserved upon respond number 1 to 3, 4, 6, 8, and 10 on account of non-availability of the person at the given address. Respondent number 7 has been served. Accordingly, notice upon respondent number 7 is accepted as valid. Respondent number 5 has appeared through mechanism. Notice upon respondent number 11 to 15 has already been accepted as valid by order dated 9/10/25. Respondent number respondent number 9 has been reported dead as recorded in order dated 9/10/25 itself, but no petition for substitution has been filed so far. The learned counsel for the appellant is directed to take press dates for service of notice upon respondent number 1 to 3, 4, 6, 8 and 10 at their present and correct address, or to file an appropriate petition seeking substituted service of notice pending. The notice, if filed, should be filed through speed post within a period of 1 month.
For substitution also you receive 1 month.
1 month.
1 month.
Within 1 month. The entry order.
Leadership.
ये तो हुआ इसका काम। Respondent number 9 तो already dead है, अभी हम इसका ये नहीं बोल पाएंगे abatement के बारे में कुछ आगे बढ़ते हैं। It has already abated 90 days तो हुई। The proceeding in connection with respondent number 9 has already abated. ठीक है? दूसरा केस में क्या है?
In this case, on behalf of the respondent, we have filed an interlocutory application making a prayer for vacating the interim order of stay for the reasons that, so far as that appeal is concerned, that arises out of the proceedings which were initiated on the application made under Order 21, Rule 99 by the present appellant. And the original suit was eviction suit. The respondent was the plaintiff.
You file a response to this.
I'll file it. But may I just, for your lordship present, para 14 of the IA is very important, which my learned friend has filed. That may I just read it? It will end every dispute. That the property sought to be executed through execution case number 797, which is my case wherein I have filed
Order 21/97 is 2 room along with a latrine, whereas the suit property involved in the other second appeal 154/2024 comprises of 10 rooms including the said room. Now, my lord, the first case which your lordship has just passed an order, that comprises of the suit property, entire suit property where the title has been decided in my favor. And this present case, wherein I am a objectioner, wherein my lord, my 2197 was there, and 2197 has to be seen. And Rule 104 says that any order under Rule 101 or 103 will be subject to the result of the pending suit. So the first one, my lord, which I have won, and because of there is a tendency of appeal, that's why they have been tagged together. It's related to the same subject matter. I'll file a response to it, madam.
So you are concerned only with 2 rooms?
No, entire property.
Entire.
Yeah, that's why both
That
the
is
matters were
occupied
tagged
by
together.
another person, the defendant of eviction suit. He is in occupation, and that suit was decreed in favor of the respondent. And there is another execution brought by them for execution of the decree which is assigned in the other second appeal.
You see, now, so far as respondent number 9 is concerned in the other case, he is dead. I have already recorded that the proceeding has abated. If they do not take steps, the court will proceed accordingly, right?
No,
Just a moment. So far as the steps in connection with other persons are concerned, I have already directed that they may take steps at their present and correct address, or they will file a petition for substituted service of notice. That is also preemptive. If they do not comply with that, the court will proceed against them in their absence, right? So this will not take much time to mature. I can reduce the time to a little bit less, maybe by 5th of.
only thing which
महीना तो दिए हैं, 1 महीना तो ऐसे
which we are trying to contend is that so far as the execution case which has been stated,
No,
that arises out of the eviction suit wherein the defendant is a different person. He is not a party to any of these proceedings.
We'll see that later.
And so far as the entire 10 rooms are
At the
concerned,
time of tagging this also, we have heard you at length. It is not that we did not heard, we did not hear.
at this, so
At the time of tagging also, and at the time of grant of stay also, we have heard you at length, I remember.
that is true. So far as tagging is concerned, there is order. But execution is concerned, there is a separate execution case brought by them. So in respect of the entire suit premises, and this is the execution case brought by us, since we have been found to the decree holder, and therefore we have brought it against the tenant at that point of time. And there is one thing that the sale deed which was executed in our favor, that was at an earlier point of time, and that was executed at Hazaribagh.
We will see that. We have to look at the entire records of the case before we take a call on stay vacated. So it is better that we decide the case inside.
And when
In the meantime, you may respond and you just get prepared, you prepare your notes. आप तैयारी करिए.
In this appeal, we are ready. Second
What
appeal.
about the other appeal? आपके other appeal में respondent नहीं appeal करते.
In this,
We proceed ex parte appeal.
yes, madam.
कौन है? आप you are not there. You are not the same person in the other.
no, in that case, so far as this respondent is concerned,
Yes.
he is the appellant in that case.
Okay.
He is the appellant in that case.
In his appeal, this is the other one.
Yes, the presented in which.
153.
Yes.
Are you the same respondent or there are
The
different-
respondent in this case is appellant in the other second appeal.
Maybe.
Yes.
So therefore you ask your client to be present.
No, he is
Why they are absenting in
He is the appellant. He is the
appellant.
appellant in that case. He is already present. He is represented
He is
by
the appellant.
Mr. Nikhil. He is the appellant. He is the
appellant in this
He is the appellant.
And both the property in my appeal is 0.79 acres. That is almost 80 decimals. In this, just one property, standing property, in which dispute is of rooms.
We will hear you.
These are absolutely different
We will
in
hear you.
And
in the
therefore, we
stay
are making a
vacating
prayer for
also.
stay
It is
vacating of
actually
the
Respond
appeal.
to the stay vacating.
Cause of action is different in
We'll see. आप notes बनाइए. देखिए ऐसा कहानी हमको समझ में आता है. I take my own time to understand. IN number 16486 of 25 has been filed seeking vacation of interim order of stay passed by this court. The counsel for the appellant submits that prior to the next date of hearing, a response to the interlocutory application will be filed. 15. Offensive tax की पोस्ट
15 दिसंबर में
15 दिसंबर आइए आपको लेकिन एक नहीं 15
January,
दिसंबर नहीं
no,
जनवरी आइए या आपको स्पीड पोस्ट नोटिस एक महीना में करना
to be
I do not know 50
in 154.
Yes.
154
Yes. I will. I'll try to do it this month.
What is the interim order, madam?
interim order passed in such and such
153 2018.
153 2018 is directed to continue till 15th of January.
Orders with effect Item 7, second appeal 212 of 2022.
Type copy.
SC number 212 of 22. Time till 9th of January is granted to the applicant to remove the surviving defects greatly. If the defects are removed within time, post on 20th January.
Item 8, second appeal 39 of 2023.
Leadership, we have removed all the defects. One defect is only defect number 15. In
One
which,
five.
yes, 1 5. In which case nature in certified copy is wrongly in certified judgment and decree of
That requires correction.
that requires correction.
It has to go. Judgment and decree of the appellate court or the fact court.
Judgment and decree of appellate court.
Essay number 39 of 23. In view of the office note, that the judgment and decree of the, that the certified copy of the judgment and decree of the appellate court be sent for correction. The office to indicate the error in the judgment and decree. Error / mismatch in the judgment and decree. You have filed IA for ignorance.
Leadership, there was a preemptory order.
IA number 13754 of 25 is closed. Post on 7th January.
Item 9, second appeal 228 of 2023.
Correction की है ना कलर कोड में कंप्लीट करेक्ट है
इसमें सारे डिटेल्स रिमूव हो गए.
Dated 25/8/2025
The learned counsel for the appellant has submitted that all the surviving defects have been removed. Office to check. Post on 7th of January.
Item 10, second appeal 234 of 2023.
Yes. IA for
9372/2023 for leave to file appeal on behalf of the appellant law. You are not the appellant's husband was party in title appeal law and he died during the day before that law
and his name is coming in degree. And applicant is
When did he die? What is the date of death? डेथ सर्टिफिकेट लगाए ना?
हाँ है क्या?
बताइए
डेथ सर्टिफिकेट
कब डेथ हुआ?
11/3/2011 and death certificate is initial 1/3 सदर हॉस्पिटल का है उसमें
11/3/2011 को डेथ हो गया। आप अपीलांट थे कि डिपेंडेंट?
हम डिपेंडेंट थे, शुरू में भी डिपेंडेंट थे, हमारे हस्बैंड
अपील में
रिस्पोंडेंट
रेस्पोंडेंट।
but with the tendency of the title suit itself, he died but he the defendant appellant in court below. I have not substituted name of the
आपने
appellant.
बताया था कि डेथ हो गया है।
अब तो पार्टी नहीं थी वो।
आपकी जो कोड डिपेंडेंट थे वो कौन थे? आपके
Husband,
फैमिली मेंबर थे?
husband
कोड डिपेंडेंट
कोर्ट डिपेंडेंट कुछ नहीं बताया।
कोड डिपेंडेंट कौन थे?
कोर्ट डिपेंडेंट कुछ
आपके फैमिली मेंबर्स थे?
हाँ फैमिली मेंबर्स थे।
उन्होंने बताया नहीं
बताया।
रिटन स्टेटमेंट फाइल किए थे आप?
और they are appellants. Like co-defendants, we are appellants in the improved judgment. And they have not told me when being the member of the family that there is a case pending. Therefore, this was part against this person. And again, that is clarified. So this petition is for leave to file this appeal.
ना आसानी से भी नहीं मिल रहा है। एक आपके अगेंस्ट प्रोसीडिंग एक्स पार्टी हुआ था? Did you file your written statement?
No. No, yes.
Your husband, did he file a written statement? Or not?
Number 7 was.
Your husband was dependent number? The husband was dependent number?
Defendant number 7A. Defendant number 7 was mother-in-law of his appellant. After death of defendant number 7, his 3 sons have been substituted, in which is 7. 1 was husband of this appellant.
7 was the husband of the appellant.
Right.
Did he file any written statement?
He did not file any statement, or the 7 was filed.
And your interest was also represented by your mother-in-law, who was original party in the suit.
Yes.
Must have filed the written statement. Did she file the written statement?
Yes.
She filed the written statement.
Yes, yeah, filed.
So whatever written statement she has filed, we govern everybody. ऐसा कोई nullity नहीं हो जाएगा।
Decree was in favor of defendant number 7. That was reversed in the appellate court. In which the dead person was party.
But you were, that's right. In which the dead person was party, when the decree was allowed in favor of defendant number 7, then also a dead person was a party.
No, not allowed.
क्यों decree trial court का decree हुआ ना?
Trial court decree हुआ.
Trial court का जब decree हुआ defendant number 7 या legal years के favor में.
No, reverse favor में हुआ and appellate court उसको reverse कर दिया.
ठीक है, जब डिग्री उनके फेवर में हुआ तब तो कोई ग्रीवेंस ही नहीं था आपको।
नहीं, case on the play in the suit was that the defendant number 7 has executed a state in favor of plaintiff. And so in that case, defendant number 7 was.
We have a meeting right now. थोड़ा स्टेटस समझ के आइएगा। रिटन स्टेटमेंट फाइल किए कि नहीं किए? किसको जजमेंट में? हाँ जज। At the request of the counsel for the appellant, pose this case on 15th of January.
15.
Yes, I read.
Your
Lordship, in serial, I'm mentioning serial number 42, Lordships, maybe fixed for tomorrow, day after tomorrow, Lordships.
What is the
Guardianship Act का case है, Lordship. Child is a daughter, girl child है, Lordships.
what सुबह से क्या कर ऑर्डर्स में है
Hearing.
Hearing में, Lordships. तो Lordship एक डेट फिक्स कर देते,
अदर
कंसेंट
साइड
नहीं,
अपील हो
हाँ अपीयर हो गया Lordship, कंसेंट नहीं ले पाए थे इसलिए मेंशन सुबह नहीं कर पाए, लेकिन लिस्ट में आएगा तो Lordship वो देख लेंगे इसलिए अभी मेंशन कर रहे हैं।
लिस्ट में तो 100 केस आते हैं हम तो
मतलब
2-3
Lordship
केस नहीं कर
सप्लीमेंट्री
पाते
लिस्ट
हैं।
में Lordship अगर आ जाएंगे तो आ जाएगा तो Lordship
नहीं अभी छुट्टी के पहले नहीं हो पाएगा मैडम आई इतना कैपेसिटी हमको नहीं है काफी
ठीक है Lordship, a date में भी फिक्स
डेट इज ऑलवेज देयर
Lordship, डेट फिर नहीं
डेट ऐसा होता ही नहीं है कोर्ट में हमेशा डेट we don't have any case rather we are trying to ensure that every second appeal and first appeal has a date क्योंकि यहाँ पर 100 केस सेकंड अपील डिफेक्टिव पड़े हुए हैं और 100 से भी ज़्यादा फर्स्ट अपील डिफेक्टिव पड़े हुए हैं और वो उसका कोई डेट नहीं है उसका कोई ट्रेस नहीं है तो सबको हम लोग स्ट्रीमलाइन में लाने की कोशिश कर रहे हैं केस जब भी टेकअप हो इट विल टेक इट्स ओन टाइम जब आप बहस करेंगे तो बोलेंगे हमको अच्छे से सुन लीजिए विल आई बॉदर फॉर अदर केसेस नो इजंट इट तो अच्छे से सुनने के में टाइम लगता है लेकिन इसको चैनलाइज करने की कोशिश करते हैं विल इफ द केस विल बी टेकन अप टाइड अप तो नहीं होगा
No Lordship.
थोड़ा सा छुट्टी के बाद ही हो पाएगा वेरी शी गर्ल चाइल्ड स्टडीइंग वेयर
Studying in St. Francis School, Lordship.
Ranchi what is her age
6 years, Lordship.
you are the applicant
Her mother and father both have been died, Lordship.
you are the applicant
Yes, I'm the applicant.
how are you related to the child
I am the Mossy, Lordship.
Mossy the child is with whom
Her chacha, Lordship.
धनबाद का केस
Lordship, रांची का ही केस है.
अदर साइड कौन आप हैं
नहीं Lordship, अदर साइड यहाँ पे नहीं है.
आपने उनको खबर किया है
मेंशन के लिए तो खबर नहीं की क्योंकि आज नहीं मिले तो हम उनसे कंसर्न नहीं ले पाए इसलिए नेक्स्ट डेट के लिए हम प्रे कर रहे थे कि कोई डेट देते तो Lordship जब भी कभी जनवरी का भी बस एक डेट जिसमें वो ठीक है पूजा बस
चाचा के साथ कौन है
चाची भी है Lordship और बच्चे भी हैं वहाँ लेकिन और भी इश्यूज है पहले का
Why should Mossy get
Lordship क्योंकि एक लव पहले इन लोग का लव मैरिज था इन लोगों को घर से निकाल दिया गया था एंड जब डेथ हो गई दोनों की तो फॉर ग्रैबिंग द प्रॉपर्टी Lordship वो लोग आ गए क्योंकि इतने दिन से कोई टच में नहीं थे ताकि उनका पेंशन क्योंकि वो गवर्नमेंट जॉब में थे इनके फादर बच्ची के फादर तो ताकि पेंशन इन लोग को मिल पाए Lordship इसलिए और इसके लिए कंप्लेंट केस भी पहले हुआ है क्योंकि पहले भी परेशान
How did they die?
कोरोना Lordship मदर डिड टू कोरोना
इसको कल एक बार देखेंगे क्या है कितना पकड़ने लायक है उसके बाद देखेंगे
जी Lordship